Good morning, everyone. A warm welcome to all of you to the fourth and final session of our drafting internship organized by the Nyayavani Foundation. I am Aradhya, your host for today's session. I am truly delighted to be here with all of you as we continue this journey of learning and growth together. I request all the participants to kindly keep your cameras on during the session and actively engage to make the session as interactive and enriching as possible. Before we begin, let me briefly share about the Nyayavani Foundation. Nyayavani is a non-profit organization founded by Mr. Deepak Sarma So. Nyayavani Foundation is dedicated to providing access to justice through legal aid, awareness, and capacity building initiatives. Along with community outreach, we focus on training, nurturing the next generation of legal professionals by creating opportunities for experiential learning and mentorship through programs like this internship. Today, we are honored to have with us Advocate Radhika Prasad, partner at Nyanistha Legal, who practices before the Honorable Supreme Court of India, the High Court of Kerala, and various tribunals. We are truly privileged to have her as our mentor for today's session. I am confident that her insights will add immense value to all of us. Before we begin, participants are requested to keep your microphones on mute throughout the session to avoid any background noise. Also, a gentle reminder to ensure timely submission of your assignments as per the internship guidelines. Without further ado, I would like to hand over the mic to ma'am for her insights on the topic. Over to you, ma'am.
Thank you, Aradhya. That was a warm welcome. So, since everyone are present, we can start. Good morning, everyone. So, today we will be discussing divorce in India, its types, and particularly mutual consent divorce under various personal laws. So, you might have covered the topic divorce. So it is basically a legal termination of marriage by a competent court. After divorce, the marital status of the wife and the husband, as wife and husband will cease, and they may be co-owning many properties. So that will happen to end. So there are many legal aspects for this point. So, depending on the religion of both the parties or by secular law like the Special Marriage Act, many personal laws are governing them. So, there are various types of divorce in India. Firstly, fault-based divorce. This is unilateral divorce. Either one of the parties, that is husband or wife, may initiate this. So, normally, the party has to prove a matrimonial offense by the other, such as adultery, cruelty, then desertion, conversion, mental disorder, etc. I guess you have covered that point. I am assigned the topic divorce by mutual consent. Am I right? Can
Uh,
anyone ask me?
yes, Radhika ji, actually, we haven't covered the divorce part yet. So, if possible, you can just throw a brief highlight on that part also. Um, else, as you wish to continue.
Sure. I actually prepare for mutual divorce. Since you have asked, I will just briefly introduce what it is.
Thank you. Thank you.
So basically, divorce means legal termination of marriage by a competent court. So, in mutual divorce by mutual consent, both the parties agree to terminate the marriage by filing joint petition. But when it comes to unilateral divorce, either husband or wife will move the court individually. So the other person may have objection and they file objection, and the case will go on like that. But in mutual divorce, the course of time is very less. That is why many parties resort to mutual divorce. So, based on the religion, the divorce, the procedure is different concerning Hindu law, Christian law. Christian law, the relevant act is Indian Divorce Act. Then we have Special Marriage Act. Muslim law, we have various sects like Sunni, Shia, Hanafi law, etc. So that is basically unilateral divorce. May I move on to mutual divorce by mutual consent, Deepak?
Yes, ma'am. You may.
Okay. So divorce by mutual consent is when the spouses agrees that the marriage has irretrievably broken down. They don't want to continue with the marital status, so that requires a joint petition, and they move the court with the agreement of both the parties. We will cover under various personal laws. Firstly, we are moving on to the Hindu law. So the relevant provision under Hindu law is 13B of Hindu Marriage Act 1955. Do you have that bare act or anything, or can anyone read that section 13B? Is anyone volunteering?
Aradhya, can you do that from your side?
Or do you want me to read that?
Okay, sir, just a moment.
Under Hindu law, section 13B is divorce by mutual consent. So this is the relevant provision when we deal with mutual consent for Hindus.
Okay, so section 13B of Hindu Marriage Act tells that subject to the provision of this act, a petition for dissolution of marriage by a decree of divorce may be presented to the district court by both the parties to a marriage together, whether such marriage was solemnized before or after the commencement of the Marriage Laws Amendment Act 1976, on the grounds that they have been living separately for a period of 1 year or more, that they have not been able to live together, and that they have mutually agreed to the marriage should be dissolved on the motion of both the parties made not earlier than 6 months after the date of the presentation of the petition referred in subsection 1, and not later than 18 months after the said date. If the petition is not withdrawn in the meantime, the court shall, on being satisfied after hearing the parties and after making such inquiry as it thinks fit, that a marriage has been solemnized and that the averments in the petition are true, pass a decree of divorce declaring the marriage to be dissolved with effect from the date of the decree.
Okay. Is anyone talking?
Azad, I request you to kindly mute yourself.
Okay, did you understand, Aradhya?
गवर्नमेंट सर्विस का नहीं दिया हुआ वो उससे
Let me
उसमें
just
ऊपर से दिया हुआ कि
confirm.
इतने डीएम है इतने एसपी है
Hope you
इतने
are all
इंस्पेक्टर है
requested to kindly keep yourself muted unless asked to unmute. Yes, Radhika ji, you may start.
Okay, so divorce by mutual consent under Hindu law, mainly, firstly, both the parties, husband and wife, present the petition for dissolution of their marriage before the district court. So it will be a joint petition signed by both of them. The marriage may be solemnized before or after the Marriage Laws Amendment Act. That is not material. So they have to. The ground is that both of them has been living separately for a period of 1 year or more. So the main part is that they might have been living separately for at least 1 year. Well, for at least 1 year, they shall be separated. And secondly, they have not been able to live together. They don't want to live together, or the marriage is irretrievably broken down, that they are not able to live together as husband and wife anymore, and that they have mutually agreed that the marriage should be dissolved. That means their agreement agreement that the marriage should be dissolved should be mutual. That shouldn't be under any coercion or any undue influence. So these are the three main points: that they shall be living separately for at least one year period. Then they are not able to live together as husband and wife anymore. And thirdly, they are mutually agreeing that the marriage shall be dissolved. So these are the 3 points mainly. And secondly, firstly, they will file this petition for a dissolution. And their usual practice is that the judge will ask them to attend their counseling. And that counseling, the counselor will ask questions to them to see whether they can be continue as husband and wife or not. And we can move on to the second clause of the section. On the motion of both the parties made not earlier than 6 months after the date of the petition. So this is a cooling period. Firstly, we file the petition. Secondly, the parties has to wait for 6 months. That is the cooling period. 6 months is the lower limit. The upper limit is 18 months. 6 to 18 months is the cooling period. And meanwhile, either of the parties or both the parties can withdraw the petition for mutual divorce. That means in the meantime, they are feeling that they don't want to move further, or they can live as husband and wife. During the schooling period, they are able to withdraw this petition. And if the petition is not withdrawn in the meantime, the court will ask certain questions to both of them. If their consent is free will, is there any coercion, or is there any terms on which you guys are dissolving your marriage? And is there any children born out of your wedlock? Or is there any settlement that needs to be happened? So after satisfying that the marriage has been a valid marriage has been solemnized, and they are not able to live as husband and wife, the averments in that petition are true, the grounds are solid, a decree of divorce is passed by the judge that they are not a husband and wife from the date of that decree. So this is what is the procedure under Hindu law. Is that clear? Am I clear? Do you have any doubts on that?
Folks, you are free to ask if you are having any doubt, or kindly respond through chats or a thumbs up will do.
Okay, I can see the chat. I guess that's clear. So I have told that there is a cooling period of 6 months, 6 months to 18 months. So if someone want to withdraw their petition, they can withdraw during that period. So in a pattern of cases, the judges of different high courts has ruled that this cooling period can be waived. That means if they don't want to wait for 6 months, they can file a petition for waiving this cooling period, and they can move the second motion immediately after 7 days or something. This is the practice. So that is firstly decided in the case Amardeep Singh versus Harvin Kaur 2017 for KLT 367 SC. Do you want me to type the citation in the chat?
Ma'am, I don't think so. It is needed. We will share them all the subject material after that in the group itself. You may
Okay, sure.
proceed with it.
Okay. So, in this case and after this case, the Supreme Court and the various high courts, High Court of Kerala, High Court of Punjab and Haryana, they have decided that the schooling period of 6 to 18 months can be waived off. Okay, so that is the uh, personal law, Hindu law. Then we will move to Special Marriage Act. Can anyone read? I will tell the provision, or do you want me to read? The relevant provision is Section 28 of the Special Marriage Act.
Ma'am, do you want to share the screen of the Bear Act?
Not necessary. If anyone can read, that is fine.
Okay, Aradhya, can you do the same?
If someone reads that, that will be registered in their mind. The provision is somewhat similar. Or I will read, it's fine. Yeah.
Yes, ma'am.
Section 28 of the Special Marriage Act, divorce by mutual consent. Clause 1. Subject to the provisions of this Act and to the rules made thereunder, a petition for divorce may be presented to the district court by both the parties together on the ground that they have been living separately for a period of 1 year or more, that they have not been able to live together, and they have mutually agreed that the marriage should be dissolved. Subclause 2. On the motion of both the parties made not earlier than 6 months after the date of presentation of the petition referred to in the subsection 1, and not later than 18 months after the said date. If the petition is not withdrawn in the meantime, the district court shall, on being satisfied after hearing the parties and after making such inquiry as it thinks fit, that a marriage has been solemnized under this Act and that the averments in the petition are true, pass a decree declaring the marriage to be dissolved with effect from the date of the decree. So there is no much difference between Special Marriage Act and Hindu Marriage Act regarding divorce by mutual consent. The elements are same. Firstly, they must have lived separately for at least 1 year, 1 year or more, that they are not able to live together anymore, and they have mutually agreed that the marriage should be dissolved. And after filing this petition, again they have to wait for 6 months after the date of such presentation of the petition. And if that presentation is not withdrawn during the schooling period, on being satisfied, the judges will ask relevant questions as to their vetting, any terms of settlement or custody of the children if they have a child out of wedlock. So the judge thinks that as valid marriage is solemnized under this Act only, and the averments furnished in the petition is true, and they don't want to live together, the judge will declare that the marriage is dissolved. Same as Hindu law. Is that clear? Are you guys following me? Shall I move further?
Yes, ma'am, you may move further. And actually, we have also planned a Q&A session and the doubt session after this session,
Sure.
after we complete all the partner.
Sure, then I will move.
Okay.
So now we are going for Muslim law. Muslim law, as you know, there is no codified law. It is different for various sectors. There is difference in Shia law. There is difference for Sunnis. So generally in Muslim law, there are 2 types of divorce by mutual consent. Firstly, that is Kula, and secondly, that is Mubarak. So in Muslim law, when a wife can initiate a divorce, usually husband initiates a divorce, that is husband pronounces talaq. You might have heard that. You might be studying that further when you have a session on divorce, unilateral divorce. So usually husbands pronounces talaq, that is of 3 types, and that marriage is dissolved on the initiation of husband. So when a wife initiates a divorce and husband agrees to it or consents to it, it is Kula, Khula, or Ahul, Ahul. So for that, the wife is asking to release her as a wife to that husband. So for releasing her, she must have offer a consideration to the husband for obtaining such a consent, that is usually returning the dower or mahar, whatever you call that. So dower, you might be knowing that, right? Dower is something the husband gives to the wife at the time of their marriage or their wedding. So for obtaining the consent to dissolve the marriage, the wife pays this portion of the dower or the whole dower to the husband back, or it may be some property, movable or immovable. So this is why the Kula is also known as divorce by purchase, because the wife asks for release of her by paying a consideration. That is why it is also called divorce by purchase. So actually means to put off, KHUL. It can be done by herself or an agent on behalf of her. In Hanafi law, the guardian of the minor can do that. Ashita, your mic is on. Okay. So, Kula can be done by the wife herself or an agent on behalf of her. In Hanafi law, this guardian of a minor wife can actually initiate Kula. But in Shia law, no guardian can initiate Kula on her behalf. Then for Sunnis, there is no specific form. Then there is conditional kul and unconditional kul. In conditional kul, if the meher is not paid, the marriage can be revoked actually. But in unconditional kul, if that consideration is paid, that marriage is irrevocable. Sorry, that divorce is irrevocable. It will not be back to how it was. So consideration I have already told, it might be a meher, returning the meher given to her, or the properties movable or immovable. So it shall not be illusory. At least something shall be given. If the consideration is not given by wife to the husband, then the husband is not bound to release her. And it is not necessary that the consideration shall be given at the time of kula or not. It can be decided later on by the husband and wife themselves. And once that consent is given by the husband, it is irrevocable divorce. And the wife can actually, before the, like you might have covered Contract Act, before the acceptance by the husband, the wife can actually withdraw the kula. So the procedure is wife asked to release her before the husband accepts. If the husband is yet to accept that kula, the wife can actually withdraw. That is firstly kula. Then there is mubara, M-U-B-A-R-A-A or M-U-B-A-R-R-A-T, mubarat. Mubarat or mubara, you can tell anything. So wife and husband agrees to divorce mutually. Both of the parties want to agree, and meher is given wholly or partially back by the wife to the husband. It is not actually a mandatory condition. Meher may be given, meher may not be given. So both in mubara and in kul, there is that iddat period. Wife has to wait. Wife have to wait for some period, and after that the marriage is dissolved. So that is Muslim law. Is that clear? Then we can go to Christian law. So for Christian law, the governing act is Indian Divorce Act. So in Indian Divorce Act, Section 10A is the dissolution of marriage by mutual consent. I will read it. 10A, dissolution of marriage by mutual consent. Clause 1. Subject to the provisions of this Act and the rules made thereunder, a petition for dissolution of marriage may be presented to the district court by both the parties to a marriage together, whether such marriage was solemnized before or after the commencement of the Indian Divorce Amendment Act 2001, on the ground that they have been living separately for a period of 2 years or more, that they have not been able to live together, and they have mutually agreed that the marriage should be dissolved. Marriage should be dissolved. Secondly, on the motion of both the parties made not earlier than 6 months after the date of presentation of the petition referred to in subsection 1 and not later than 18 months after the said date, if the petition is not withdrawn by both the parties in the meantime, the court shall, on being satisfied after hearing the parties and making such inquiry as it thinks fit that marriage has been solemnized and the averments in the petition are true, pass a decree declaring the marriage to be dissolved with effect from the date of decree. So Christian law is similar to, the practice is similar to Hindu law and Special Marriage Act. The only difference is that under Christian law, the spouses have to be living separately for a period of 2 years. Earlier, it was for a period of 1 year in Hindu law and Special Marriage Act. But under Indian Divorce Act, they must have been living separately for at least 2 years. And the cooling period is same 6 months to 18 months. If they have to withdraw, they can withdraw. And if the petition is not withdrawn, the judge will hear both the sides and pass the decree of the dissolution of marriage. That's it. So we have covered almost all personal laws. So concerning this topic, the key points are voluntariness. Voluntariness. The petition must be filed by both the spouses voluntarily. That means the consent must be free, mutually agreed. Then there is a separation period. Hindu law and in Special Marriage Act, they must be living separately for at least 1 year. And when it comes to Christian law, Indian Divorce Act, the separation period is 2 years. Then court's role is that the court judges will see themselves that the petition is filed genuinely. There is settlement on child's custody, alimony, and property owned by them. The judges will see all these things. Will see that a valid marriage is there between them, and they cannot live anymore together as husband and wife, and they will pass a decree. And the schooling period is for public policy. If there is at least any chance for reconciliation, the parties shall be given that chance. That is why there is cooling period. Usually in practice, most of the parties will waive this period. But if there is any chance for reconciliation, the cooling period is very essential. And just like that, the marriage between them is dissolved. It is less time consuming that the unilateral divorce, wherein the husband or the wife will move for divorce unilaterally. So that's it. Now we can move further to the questions or draft. Okay, so this is the format. Firstly, the post title, before the Honorable Family Court at Irinjalakuda. So this place can be deferred based on the jurisdiction. That jurisdiction is decided based governing the personal laws. So where you are filing the petition, that place shall be added here. Here the place is Irinjalakuda and the OP divorce number. OP means original petition. Before filing, we will leave this place as blank of 2025. We have to affix a photos there. That is why there is some space here. Husband is first petitioner here, wife is the second petitioner. It can be changed. The first petitioner can be a wife, and respondents are nil because they are moving together. That is why they are added as first petitioner and second petitioner. There is no respondents. That's why we keep the column nil. So this is Hindu Marriage Act. The relevant provision is 13B of Hindu Marriage Act. That is why we have written here petition filed under section 13B of the Hindu Marriage Act 1955. When you write a provision, the act shall be written in full. I have seen the practice that we just write CPC instead of Code of Civil Procedure Code without mentioning 1908 here. The correct practice is we write the provision and the act in full itself. Okay. Firstly, the petitioner belong to Hindu community and are governed by Hindu Marriage Act for the purpose of dissolution of the marriage. So firstly, the judge knows nothing about the marriage, which community they are belonging to. Why this petition is filed under this provision? Because they are coming under Hindu community and they are governed by this act itself. That is why we are filing this petition under this provision. So firstly, we have to say that there occurred a valid marriage between them. So the marriage between the petitioners was solemnized on this day. Okay. Okay. And as per the Hindu rites and ceremonies at so and so temple, Trishur. So valid marriage has happened on this date at this place as per the Hindu rites and customs, and they are under this community. So we are filing this under Hindu Marriage Act. So we have to produce the document, marriage certificate, proving that there is a valid marriage. That is, the petitioners are producing the marriage certificate dated this, issued by the local registrar of marriages, common, Melur Grama Panchayat. So that is the first document produced by us. And secondly, it is submitted that the petitioner started residing as husband and wife at the residence of first petitioner at Thrissur. During the very inception of the marriage, serious differences and disputes have arisen between first petitioner and second petitioner, and it has become impossible for them to lead a peaceful marital life. On account of incompatibility between the petitioners, they have ceased to live as husband and wife from 2021. So today, 2025, from 2021 onwards, they are living separately. So the first condition is satisfied, that they are living separately for more than 1 year. And no warmth of relationship exists between the petitioners as they have lost the rhythm as husband and wife. Second condition, we are going to the second condition. As you can see, the marriage between the petitioners is irretrievably broken down without any scope of reunion. And the petitioners are not living as husband and wife from that set date. Despite the earnest efforts by trained counseling experts, the petitioners could not reconcile their relationship as husband and wife till date, and no children are born in the wedlock of the petitioners. Understood? And now, from the set date onwards, the petitioners are not living as husband and wife. Neither they could reconcile during the period, nor they have resumed cohabitation. That is very important. After that 1 year, they should have resumed cohabitation. If they resume, the marriage, the solution cannot be applied for. Now, further, the petitioners do not have any intention to cohabitate, that they are not willing to live as husband and wife anymore. They don't have any rhythm as in their marriage. They cannot further reconcile. So the marital relationship between them is irretrievably broken down. The petitioners last resided together as husband and wife at the address of the first petitioner. So this is telling about the jurisdiction. This the place where the petitioners last resided together as husband and wife. Hence, we are filing this petition before this honorable court. Next, hence, both the parties have decided to dissolve their marriage by mutual consent for their welfare, well-being, and future prospects. It is mutually agreed by both the parties that they do not have any monetary claims. So this part is the terms of divorce. If they have any monetary claims or liabilities against each other, they will list here that the first petitioner agrees to return the gold given to them to the other on the date of the evidence or anything. In this case, there is no monetary claims against each other. So there is hardly any terms here. Neither petitioner has any claim over the other's movable or immovable properties or assets. Furthermore, there is no gold, jewelry, or any valuable items to be recovered or divided between them. And no children were born out of this wedlock. And the second petitioner shall not have any right to claim maintenance from the first petitioner as wife. And the first petitioner shall not have the right to claim from the second petitioner as husband. So they cleared that they don't have any right on the properties of each other. Then the present petition is filed with the free will of the petitioner without any coercion or compulsion. There is no collusion between the petitioners in filing this petition. The petition is not allowed. Irreparable loss and hardship will cause to the petitioners. Now, what is the statutory period? Anyone please answer? Cooling period for Hindus under Hindu Marriage Act. Okay, it's 6 months. The statutory period, the statutory period they are referring to is the 1 year. The statutory period has already elapsed from the cessation of cohabitation for filing the petition under Section 13B. And there is no collusion between the parties. There is no force, fraud, or undue influence in obtaining the consent of either parties. Now, the course of action. The last paragraph is always the course of action and jurisdiction of the court. The course of action for the petitioner arose from the date of the separation. Firstly, the date of the marriage, then the date on the separation, that is the petition, the course of action for the petition arose on 16/2/2019, the date on which the marriage was solemnized. And okay, then after they have started, they have separated or they have stopped cohabiting together. And when the husband ceased to live as husband and wife, from that date onwards, the course of action arose. And the permanent address of the first petitioner where the petitioners resided as husband and wife soon after the marriage falls within the territorial jurisdiction of this honorable court. Then the court fee is exempted, that is just a format. And the last, the prayer. The prayer must be so specific that once the decree is passed, there shall not be any instance of going to court for again. That is, it is most humbly prayed that this honorable court may be pleased to pass a decree of divorce, dissolving the marriage between the petitioner by mutual consent. Dated this day of January 2025, whatever, and it is signed by both the parties. Then there is verification. Verification is similar to affidavit. Both the parties is stating that the facts mentioned above are true and correct to the best of their knowledge, information, and belief. So both the husband and wife will sign under this verification. That is similar to the affidavit. And this is the docket. That's it. Is that clear? Yeah.
Yes.
I believe a document is given to you. It's am I audible?
Yes.
Yeah. Okay.
It
So
is a
this is
policy statement and the assignment part for the interns, ma'am.
okay. So for students, this is the question for you. This is simple because you guys had already given the format. You just need to edit the dates and places here. The petitioner, Kashibai wife, and Bajirao husband belong to the Hindu community and are governed by the Hindu Marriage Act. Their marriage was solemnized on 18/10/2013 as per Hindu rites and ceremonies at this temple, Sadhu Kalyana Mandapam, Thana, Kannur village, Kannur Taluk, Kannur district. For this district, you have to check the jurisdiction, which family court is governing this district, and a marriage certificate dated 22/10/2013 was issued by the registrar of marriage. You have to produce this certificate. Then due to serious differences, they have been living separately since 2020. So you have to check whether the statutory period under Hindu Marriage Act is covered here. From 2020, of course, 1 year have elapsed. Now, no children were born out of wedlock, so there shall not be any terms on the custody of the children. Then, as part of the settlement, husband has agreed to pay the wife a sum of 15 lakhs only, out of which 5 lakh will be paid when she returns to India this year. So she might be living abroad, and the balance 10 lakh will be paid in 2 annual installments of 5 lakh each. So this can be a separate paragraph when we talk about the terms. Further, the house at 2 Adina Court, Kurunjang, VIC 337, Australia, presently in the joint names, will be transferred to the sole ownership of Kashibai. So this property is now co-owned by both the husband and wife. For the terms, this is transferred to the wife only, and the both parties had agreed not to claim maintenance or any further monetary reliefs. So these are the terms under this question, and based on these facts, prepare a properly drafted mutual divorce petition under this section. So the sample we have already provided. This is just simple. You just have to be clear and thorough about the section. Whatever you don't have to actually remember or by heart the section number or anything. You just have to when you read a section and you have a case on your hand, you have to see whether the conditions mentioned under the act is covered or not. That is only necessary. You can then add the section and everything later. You can refer that. Okay. If there is any doubt, you can contact me or you can contact Anjali ma'am. So that's it.
Thank you so much, ma'am, for that incredibly informative and eye-opening session. Your insights have certainly sparked a lot of thought among our attendees. Now we would like to open the floor for the question and answer session. This is a great opportunity for all of you to ask your queries directly to ma'am. If you have a question, please feel free to drop it in the chat box, and we will take them one by one.
Folks, you may raise your hands and we will allow you to directly ask the questions while opening your mic. So if there are any questions, you can either drop them in the chat box or just raise your hands.
I believe the topic is clear for everyone, no doubts. Is the process similar under Special Marriage Act? Yes, Shivani, the process is similar under Special Marriage Act. We have already covered the topic. Special Marriage Act, Section 28. It is just similar to Hindu law. The statutory period is same, the cooling period is same. The petition is filed by both the parties agreeing that the marriage can be dissolved, and the judges will wait for the cooling period, ask relevant questions as to their marriage, the terms of settlement, children born out of wedlock, if any, custodial issues. And if the judge is satisfied, the decree of dissolution is passed thereafter. Same as Hindu law. Okay. Okay.
Folks, you can directly unmute yourself if there are any doubts related to this. Okay,
There
then.
is nothing.
Yes, I think there are no questions, and I think Radhika ji has conducted the webinar so well that no doubts are left. She has covered explicitly all the paths of the divorce and the mutual divorce of the Special Marriage Act, the Christian, Hindus, and the Muslims, respectively. So there are no doubts left. Still, folks, if you have any doubt, later on you can share it to us. We will convey that to ma'am, and we will try our best to resolve that.
Yeah. I wanted to ask whether the format and procedure of the divorce by mutual consent is same under the Special Marriage Act as compared to other personal laws. Yes, Himani, the format is actually same and procedure is same as we have already discussed. Uh, Although now the format we saw is actually practiced here in Kerala. Usually that is same. It is not much important. Uh, Only the conditions are seen, and sometimes in each district the format may differ according to the place of your practice. when you enter into the practice, you will get that format from your senior or anything. That is not an issue. So maybe we have seen that verification part in some districts, that instead of that verification, affidavit format is given. So there is no issues with regard to that. You will also get that according to areas of practice. So yeah, but the procedure is exactly the same under Hindu law and Special Marriage Act. If the wife demands for a maintenance, will the proceedings and draft style change? Okay, that's a good question, Ayushman, because in mutual divorce, the terms will be mutually agreed by both the wife and the husband. If there is any conflict between them, they cannot file a mutual divorce petition because it is not mutually agreed by both the parties. So if the wife demands for a maintenance and the husband is not agreeing to that, he might not be signing that the wife will the wife will unilaterally go for the divorce. If the husband is agreeing to that maintenance, the portion we have already seen, in that draft, you can see the husband agrees for paying 15 lakh or something to the wife when she comes under two installments or something. They will actually provide that under the terms terms of settlement, that the wife is demanding this amount, that the husband is agreeing to that, and it will be handed over so and so. So the draft style is same. You just have to add that clause only. Okay. Okay. Then if a couple has an interreligious marriage, under which law should they approach for divorce by mutual consent? If they are interreligious, uh, they are governed by Special Marriage Act. But you have to see, if a client is coming to you, they are saying that their marriage is happened under this act, so and so act. You have to see a valid marriage has happened by seeing the section for marriage, valid marriage. You have to see that conditions are satisfied. If only there is a valid marriage, we can file a petition for divorce. So usually for interreligious marriage, the governing act is Special Marriage Act. Okay. Okay. Any other questions? Okay. Is the legal notice sent? Usually for mutual divorce, legal notice is not required. Sometimes both the husband and wife come to see a same advocate for filing this petition, or a wife or husband comes to an advocate, and we will inform the other spouse. If they are fine with if they are fine with moving the case with the same advocate, they will appoint them only. If even it is a different advocate, there is no need for a legal notice. The wife and husband can actually communicate each other, since they are since they are mutually agreeing. It is only in unilateral divorce, that is either of the spouse is going for and the other spouse is contesting the case, a legal notice is sent. Okay. Ma'am, what if a husband or wife marries another person being in a marriage? That comes under a punishable offense, bigamy. Although they were not living together for a period of more than a year, will it amount to cruelty or any other offense? Of course, if that person has a valid marriage, and that person before dissolving this marriage marries another person, that is a punishable offense, bigamy. And yes, it will amount to cruelty or any other offense. The wife has a solid ground there. She can file for wife or husband, they can file for unilateral divorce. They can send a notice to the other person, as Ayushman asked, and without going mutually, they can file individually. That's a question you asked, I guess I answered. Is the concept of cooling off period mandatory in all religions for mutual consent divorce? For Hindus, under Hindu law, Special Marriage Act, Indian Divorce Act, this cooling off period is usually mandatory because even if there is a slight chance for reconciliation, they can withdraw the petition. But there is no any provision stating that this cooling off period can be waived. But Supreme Court and other High Court decisions are there stating that this cooling off period can be waived. So usually a petition for waiving this cooling off period is filed after the filing the mutual divorce petition, and before 6 months this case is listed for hearing and all. So that is not mandatory. Ma'am, will the judge without issuing divorce if gives mediation order, then what happens to the procedure of divorce? Actually, divorce means a competent court has to declare that the marriage between them is dissolved. So there is mediation happens when there is unilateral divorce. One party is filing a petition for divorce and the other party is not agreeing that they want a divorce. The case may be given for mediation, and during the mediation they may arrive at a conclusion that they want to live together, or they want to end that. The procedure, the time is in mediation, what we aspire for mediation is because court procedures are very time consuming. So when we resort to mediation, this time is reduced. So in unilateral divorce, if we are going for mediation, they comes under a settlement, and this procedure will be less time consuming. But usually in mutual divorce, it can happen in 1 week or 2 week. You guys can get this decree very fastly. Now, without issue, okay. Okay. Two spouses living in same building but not together, will it lead to the essential cause of divorce? Yes, they are not living together as husband and wife under a single roof. So they are living separately only. It is an essential cause of divorce. Yes. Danish, yeah. Will UCC affect this process in state like Uttarakhand? I'm not sure about UCC. What does it mean? Anyone?
It's Uniform Civil Code,
Uniform
ma'am.
Civil Code. Okay. Uniform Civil Code. Yes, if this personal laws, if Uniform Civil Code is there and this personal laws are considered, this process may change. Now, which laws procedure is considered faster? Hindu, Muslim, Christian, or Special Marriage Act? Faster. That's a tricky question because even if you cannot, if you are a Hindu, you cannot go and file a petition under Special Marriage Act. So there is no need to consider this question actually when you are filing a petition for mutual divorce. If you are a Hindu, you cannot go and file under Special Marriage Act. If you are a Muslim, you cannot go for Hindu law. So which religion you are there, and under which religion you have solemnized your marriage, you have to file that. But yes, all these three acts procedure is considered faster because mutual divorce is actually can take less time than the unilateral divorce. Ma'am, as per your expertise, do you think that UCC is required in India, although it has been a topic of controversy in India? Danish, actually, under personal laws, there is many customary rights and rights are involved in terms of marriage and living together, etc. Because in Hindus also there are different castes within Hindu. In Muslims also there are different castes. So the customary rights may change. And also for a valid marriage, for each caste there is different rights. That means Saptapadi, Kanyadan. So these all differs according to their custom. So it is better to have a personal laws for different religions. That is only my personal opinion. This may change. Now, that was just okay. It's okay.
Radhya, I think it's a time we should conclude the session.
Yeah. Hope the topics are very clear to you. If you have any further doubts, you may tell the coordinators. I will be happy to answer all that. The session was nice. Thank you.
Thank you so much, ma'am, for such an enlightening and thought-provoking session.
Thank you,
Your words have
Aradhana.
truly inspired us and will definitely help all the interns refine their drafting skills and broaden their perspectives. To all our interns, we hope today's session has been a valuable learning experience. Please ensure you reflect on the takeaways and incorporate them in your upcoming submissions. On behalf of Nyayavani Foundation, I extend heartfelt gratitude to Advocate Radhika Prasad for her time and mentorship and all the participants for your active involvement. With this, we formally conclude the fourth session of our drafting internship. We look forward to seeing you all in the next session with same enthusiasm. Thank you and have a wonderful day ahead. Thank you so much, ma'am, once again.
Thank you. All the best, students.